Thank you, Mr. Chairman. I do appreciate that. The title of this hearing is Threats to Reproductive Rights in America. The rights mentioned in the title refer to the Supreme Court's 1973 decision in Roe v. Wade. As members of the Judiciary Committee, it is appropriate to examine why the test of time has exposed Roe as a failure in the viable judicial precedent. As mothers, fathers, sisters, brothers, and friends, it's necessary to consider why Roe is a failure of compassion for both women and children. While Roe asserts a woman's right to privacy anchors her right to an abortion, abortion destroys the right to life, along with liberty, the pursuit of happiness, and all other constitutional rights of the children it kills. It's impossible to imagine the framers intending the right of privacy to eclipse one of the self-evident, unalienable rights that motivated the birth of our nation. Contending an unborn child has no life to lose becomes impossible when we reflect even momentarily on what abortion entails, and I'm grateful for our witnesses today who are here to give us a look at the lives abortions would have snuffed out. These witnesses are not alone in recognizing the humanity of an unborn child. In her dissenting opinion in Gonzalez versus Carhart, Justice Ginsburg argued that compared to a partial birth abortions, the common dismemberment abortion method could have equally been characterized as brutal, involving, as it does, tearing apart a fetus and ripping off its limbs. Let us then be honest. Let us not speak of abortion as a victimless crime. At best, abortions aim to ease one person's suffering at the expense of another person's existence. We must cultivate compassion and practical support for women who find themselves pregnant under difficult or oppressive circumstances, and we must protect the most defenseless humans among us, those living in the womb. One person's reproductive right cannot outweigh another person's right to live. Justice Ginsburg also took issue with Roe on legal grounds. As a law professor, she wrote Roe, I believe, would have been more acceptable as a judicial decision if it had not gone beyond the ruling of the statute before the court. Heavy-handed judicial intervention was difficult to justify. Other pro-choice legal experts have also voiced concerns with the foundation of this decision. Edward Lazarus, a former clerk to Justice Blackmun, who wrote the majority opinion in Roe, said, as a matter of constitutional interpretation and judicial method, Roe borders on the indefensible. I say this as someone who utterly committed to the right to choose. The problem is that Roe has little connection to the constitutional right it purportedly interpreted. A constitutional right to privacy broad enough to include abortion has no meaningful foundation in the constitutional text, history, or precedent. Mr. Lazarus went on to say, as a matter of constitutional interpretation, even most liberals, if you administer truth serum, will tell you it's basically indefensible. Jeffrey Rosen, formerly of the New Republic and currently the president of the National Constitution Center in Philadelphia, wrote, 30 years after Roe, the finest constitutional minds in the country still have not been able to produce a constitutional justification for striking down restrictions on early-term abortions that are substantially more convincing than Justice Harry Blackmun's famously artless opinion itself. As a result, the pro-choice majority asked nominees to swear allegiance to the decision without being able to identify an intelligible principle to support it. Kermit Roosevelt, a law professor at Penn Law School, said, it's time to admit that in public that as an example of practice of constitutional opinion writing, Roe is a serious disappointment. As constitutional argument, Roe is barely coherent. The court pulled its fundamental right to choose more or less from the constitutional either. As a result of Roe's lack of legal justification, the Supreme Court has since limited its effect. 1992's Planned Parenthood versus Casey permitted states to regulate abortions in the first trimester or at any stage before fetal viability, provided that they don't impose an undue burden on a woman's right to an abortion. In 2003, Congress banned partial birth abortions, which none other than Justice Ginsburg had called brutal. In a partial birth abortion, a living baby was delivered, feet first, skull crushed before its chin clears the uterus, moments before live birth is complete. 2007, the Supreme Court upheld the federal ban, which applied at any point during pregnancy in Gonzalez v. Carhart, ruling the federal law did not impose an undue burden on a woman's right to an abortion. Justice Kennedy's majority opinion noted the law expresses respect for the dignity of human life and affirmed the government's interest in protecting the medical profession's integrity. He wrote the government may use its voice, its regulatory authority, to show its profound respect for the life within the woman. Mr. Chairman, the decades since Roe v. Wade has repeatedly delivered legal decisions making it clear any threat to Roe is posed by illogical majority opinion. Before I finish, however, I will have to take exception with my chairman of the full committee. To call the ranking member of this subcommittee arrogant for expressing his personal beliefs while at the same time sitting hypocritically stating your own beliefs from a belief that I would assume come from a moral or civic background is the height of hypocrisy. At this point in time, we can disagree, but at least if we're going to call the balls and strikes the same way. With that, I yield back.